Lordship, in this matter, no notice was served upon the petitioner, and addition of party application has already rejected.
As far I am concerned, Mala, that was at the investigation stage when they prayed for transfer of investigation. This Honorable Court said, we will investigate you, you don't have any say. So that was rejected at that point of time. Different story altogether, Mala. We are only on the development. The can to have filed and that was served upon my land.
Can she also, I have served, I've mailed, it has happened at 1:15, I've mailed everything to her.
Lordship, in this.
Just a minute, Madam, this was not planned in by any of us. In situation for which we move the court. Now, Madam, may I address the court, and then after that, whichever way your Lordship would decide as to how to serve, whom to serve, what to serve, everything can be complied. I just commence my arguments, Madam. I will just show your Lordship 4 pages. After that, your Lordship would.
Yes.
I have got a preliminary objection to the maintainability of the application.
Sure.
This is admittedly a non-party application for recalling the order of your passed by your Lordship, which has been disposed of from 28th of January. It is well settled law that when a writ petition is disposed of, the only remedy is available is by way of a review, even by a non-party applicant, not by filing an application for recalling. This is Hiralal Banka, Budai, all consistent cases of the Supreme Court. Secondly, this is a case where they are seeking extension of time within the new criminal law for the purpose of filing discharge petition. 3 accused have filed discharge petitions. This is being heard today, and the rest, for killing time, they have come before your Lordship. Therefore, kindly note the preliminary objection and see the prayer. They have asked for stay of all of the operation of the order passed by your Lordship. Whether this is maintainable at all.
All right, let me hear him.
Please. Madam. Manoj, pleasure would be to kindly come to page 51 of your Lordship's order. I'm very glad that the learned ASG is actually raising preliminary objections on page 51 of my can 3. I'm arguing can 3 since this is where.
With the can 3 or not?
Can 3? Yes, your Lordship is on can 3. But this was the order passed. Well, possibly, if the Central Bureau of Investigation thought it appropriate, in page 52, it would have informed as to what was the position, the factual position which was there at that particular point of time. Kindly comes to page 52. Page 52 on the top, on instructions, the learned ASG submits that even sanction has been granted for prosecution and angle of larger conspiracies being investigated by the CBI, which will consume some more time. A report has been submitted by the learned ASG, which has been prepared by the Deputy Superintendent of Police, which reflects the charge sheet was filed on so-and-so under the relevant provisions of so-and-so and so-and-so. In view of the charge sheet having been submitted almost 2 months ago before the learned special court, I direct the CBI authorities would take steps if the trial can be commenced by directing the public prosecutor of the CBI, appearing on behalf of the CBI, to assess whether the materials so collected prima facie make out a case for framing of charge before the learned trial court. After that, my lord, your Lordship can skip because they are not necessary to be heard. ED. Kindly comes to page 53. Having considered that Central Bureau of Investigation has already submitted charge sheet in the month of November 2024, and it has further been informed that sanction order has been granted very recently, I direct the learned special court that within a week from the next date, fixed all endeavor to be made for consideration of charges. The special court would take into account the list of witnesses and accordingly fix schedule so that the trial of the case can be expedited and taken to its logical conclusion at the earliest. But if this order is passed, thereafter sees the problem which starts in page 55.
Yes.
Malad kindly skips first 2, kindly sees the next. It starts with I have carefully gone through. Yes. The sanction orders passed in respect of so-and-so and so-and-so. It is manifest from the record that CBI had already filed a CS number so-and-so against so-and-so as amended so-and-so and substantive offense thereof. Since so-and-so government employees publishing due to lack of sanction from competent authority, this court could not take cognizance. Miller, please keep a note that no cognizance was taken when the Central Bureau of Investigation indicated that they have received sanction. Now, since sanction orders have been filed in respect of competent authorities, this court is hereby took cognizance of offense against so-and-so, so-and-so, so-and-so. So-and-so has admitted so-and-so and substantive offenses thereof. One of the learned counsels for the defense has filed a server copy passed in repetition number so-and-so of the Hon'ble High Court. Now sees what is happening. Before taking up the bail matter, it strikes to the conscience of this court that regarding the conduct of the investigating agency, it appears from the petition filed by the IO along with sanction orders in respect of so-and-so and so-and-so. Those sanction orders in respect of so-and-so and so-and-so accorded on so-and-so and so-and-so respectively from the order of the Hon'ble High Court.
What is your prayer?
Prayer is, my lord, we are entitled to in law to have 60 days.
Penny hearing thereof.
60 days we have
So the
in terms of the new enactment to file a discharge. But can I just show your lordship the law? We were not aware of this
it was
law.
drafted by me, sir.
If your lordship has drafted, then your
Huh.
lordship would know.
This was the passage of time which was killed earlier from transferring. that.
Cognizance was taken. It had nothing to do with us because we continue to remain in custody. Two important facts, my lord. Your lordship would kindly come.
Sir, one thing is this: against judicial orders, how can I pass this?
No, it's not a question. We are
It's a
asking
judicial
for.
order.
We are, my lord, sees the ramification of your lordship's order.
The thing is this, sir: you have got to appreciate this is a judicial order. This may be right, wrong, to your liking, to your disliking.
No, my lord. My point is not that. My point is your lordship's order has to be amended. My prayer is that. My prayer is that your lordship would please appreciate comes to 56. Sees,
Whatever you are drawing my attention to the impugned orders, you say
yes,
Yeah. any judicial order
yes.
can under Article 226. I believe aside the calling application.
My lord. Your lordship passed an order without hearing us. Your lordship thought that we were not necessary parties. Your lordship directed that within 7 days it has to be heard. Now sees what is the outcome of that. My lord, your lordship is entitled to see that.
So anything, how can a recalling application be sufficient? Is correct that the review is.
My lord, I had sought permission from. In fact, I have come only after liberty is being granted by the learned Chief Justice to approve
to file
this
the
court.
application.
I have.
You have. That is for filing the application.
No, my lord. Your lordship sees the order.
To ignore all the laws.
No, I'm not saying ignore
Chief
all the
Justice
laws.
did not say to ignore all the laws and pass the order.
No, but what, my lord, your lordship, please appreciate.
What has been the leave?
The leave is that I can file a review stroke recall. Liberty is granted and liberty given
Review
to
has
mention.
not been- review has not been stated over here, sir. It's only a recalling oblique review.
No,
review
recalling
for-
not review.
This is-
Recalling
This is a review application or recalling application.
I have filed a recalling.
But then the recalling application is not maintainable, sir.
But I have sought leave. My lord, the date is tomorrow. Now kindly sees one line, my lord. After that, if your lordship wishes to take me through technicalities of law, we would handle that later. My lord, just sees page 63. Sees the problem. Sees the problem. 62, my lord. 62, penultimate paragraph.
Yes.
My lord, now all 5 petitions filed by the accused persons as referred to herein above, taken up together by learned so-and-so opinion on behalf of a particular accused, has at the outset drawn attention of this court to the volume of documents supplied on earlier occasion. He has submitted that the entire volume contained more than 25,000 pages without any index and pagination. Right? He would further argue that in a short span of time, it was not possible for the defense to go through the entire document to file a proper application for discharge. Learned Senior Counsel, my lord, the law says, if your lordship sees, attention to the provision laid down in 230 of BNS and submitted that the accused was entitled to get such copies within 14 days from the date of production. That is the law in terms of 230. Right? And then 261, he's supposed to ensure that 230 is complied with.
From the date of production means what? The charge sheet was filed in the month of November.
Yes. And we continue to be produced. No copies were given to us.
That's interesting. I said earlier also that there was a systematic delay.
My lord, how are we responsible for that? Your lordship has to appreciate.
We're not just simply enjoying the remand, sir.
We were in custody. So how on earth, my lord? Please appreciate.
So you did not want a copy earlier also, sir.
But
to know what is the case
the
again.
court to give. The court did not take cognizance. Now we have a judicial situation over here. No cognizance was taken. If no cognizance is taken, the court says that I do not accept the charge sheet. The court says, and it is reflecting that is the reason why I showed your lordship. The IO was show caused. The show cause was accepted. The replies were accepted. Now it's not, I am not against CBI per se. I'm against an issue where 25,000 pages, my lord, I've got the pages over here. It's unindexed, unpaginated documents, a list has been given. Not only that, my lord's pleasure would be to kindly see the day your lordship passed this order, sees this situation. Sees this situation, my lord. Kindly comes to page 57. It was incumbent on the part of the CBI to bring it to your lordship's notice. Sees 57 and your lordship would understand why I'm showing 62. Sees 57 right in the middle. Now the record is considered. Now the record is considered. Right in between. Regarding supply of copies. So first time this issue is coming up is after your lordship passes the order. Kindly comes to 57 right in between. Now the record is considered regarding supply of copies. At this stage, IO of the case has filed petition contending inter alia 70% of the documents get ready for supply and paid for some more time. This is happening on 31st of January. The things were not even ready. And then your lordship, give me this list. This is the list of unrelied upon documents. This is just the list. Uncited documents, my lord. Your lordship is the acquitted. Please, acquitted. This is the list which has been given by CBI. Now, in terms of law, I have a right of inspection. Sees how am I supposed to inspect by 5 p.m. This is what the mandate of the court was because of your lordship's order. My lord, kindly have a look at this list of unrelied documents, uncited documents. Akbar Tuledin Dada, please. My lord, kindly permit me to produce this. And when I bring it to the notice of the court says, my lord, kindly sees page 63. Court sees court's observation. The third last paragraph, it starts with, I have considered, page 63, third last paragraph, I have considered respective submissions. Over there, right in between, it says, now, although section 262 of BNS enumerates provisions that an accused may prefer an application for discharge within a period of 60 days from the date of supply of copies under section 230, this court feels that in view of the specific order of the Honorable High Court directing this court to make all the endeavors to frame charge within 7 days, the court shall be complied with. So at this stage, I cannot entertain you. So where am I supposed to go? I go to that court, I say that it is for consideration of charge. It does not mean that you have to frame charge. What your lordship indicated in open court when we come for the first time.
There's the language over there, sir.
This court is of the opinion that your lordship's order is an impediment to follow 262. 262 is a mandate of law. 230 is a mandate of law. My lord, what we are requesting is only one prayer, that the procedure of law as established in BNSS should be followed. Nothing further.
But then there has been a subsequent change of circumstances.
What is the change of circumstance, my lord?
Obviously, sir, these are all judicial orders.
Passed because of your lordship's order.
So that does not mean that means what you are wanting is review of the earlier order, not recalling the earlier order.
Recall of the order because of the fact that A, I was never heard. B, CBI never indicated what the position of law was, that no cognizance was taken, no supply of copy was done. We were a necessary party. We were never made a party. That is the reason why we are praying, my lord, this order should be recalled. Because we were never heard and CBI never indicated that they were coming up with 25,000.
In a disposed of matter, where is the provision for recalling? In a disposed of repetition, where is the provision?
My lord, with greatest respect, the only way we can come up right now, in order to save time, because today we have been saved by the neck, it's been kept tomorrow. The learned counsel appearing on behalf of the CBI said that we are delaying. We show it from the documents that CBI themselves said that we were not ready. This issue should have been brought to your lordship's notice, that they were not ready. Cognizance was not taken. Supply of copies was not contemplated by CBI itself. This kind of documentation which is being given, my lord.
No, but Mr. Chakraborty got instructions from his officer who was present over there.
Well, that is not for us to understand.
The officer was present on that day before the court.
So why embarrass any of us? It is recorded.
On the relevant date when I passed the order, your officer was present in court.
And what do we get out of this? How are we going to handle that? Because we were never heard. We were never heard. If the court was misled to pass an order, my lord, with greatest respect, everybody has a right of fair trial. All that we are seeking is trial in terms of law.
No, sir, you were delaying the proceedings.
How? My lord, please ask them to produce one document whereby we've delayed. Just ask them, my lord, if your lordship is going to hold that, that's a judicial order which has been passed or will be passed. Your lordship, ask them in one day which we have delayed. One day, if they can show that we have delayed, because it's at the stage of investigation, we cannot delay. How can we delay?
How the stage of investigation?
Post between charge sheet and sanction, how can we delay if no supply of copies?
Again, I'm saying that I'm not pointing out who is the authority. You don't take in this type of charge sheets.
Yes.
More than 2 months' time to decide a sanction.
But who are we? We were not involved. We were not involved. Especially me. I don't have PC Act on me. I do not have PC Act on me. Where is the question of me not being?
Conspiracy is there? 35 or 61?
Is that
61 or 35 is there or not?
35. Let me just indicate to your lordship. Just do it. Charge sheet ta dekho. Of course, conspiracy 120B will obviously be there. 120B will obviously be. Yes, 120B is there. No, but at the same time, my lord, please, my lord, everybody's in custody. Everybody's in custody.
It doesn't give a mileage, sir.
So what gives, my lord, with greatest respect, what gives mileage? I'm asking, if I'm in custody, how is my right going to be curtailed? Your lordship, my right is going to get curtailed over here. It's a very simple issue, my lord. Law presupposes a right.
Right, obviously, sir.
If the law was presupposing a right, the CBI did not indicate the position at that particular point of time. So what am I supposed to do? That my right is going to get defeated?
No, the stage of consideration of charges are going on, sir.
No, it's been kept, my lord. Your lordship has read. Your lordship, please read. Your lordship,
the judicial order, you are trying to point out the legality and illegality, which I cannot do, sir.
It is because of your lordship's order.
You are not understanding the difference between 482, 401 and 226.
With greatest respect, the revisional court was moved by Mr. Bhattacharya. It was said that since you have a writ court order, we will not touch it. Now,
These are oral submissions. Must have the order to that.
correct. My lord,
My lord, only
correct.
my lord, with leave
Yes,
of Mr.
yes,
The difficulty is that, my lord, that time which will be consumed in order to obtain an order, my lord, by further rights will be
Tomorrow 10:40 he's kept it. There'll be framing of charge. Now without a 230, without a 262, your lordship in a writ court, your lordship would allow it because the CBI did not place it before your lordship. It's an issue where CBI did not place it before your lordship.
I don't understand what the CBI had to do. CBI had to supply the documents.
Sir,
No, they were not ready with the document. Did they indicate that they were filing 25,000 pages without pagination, without index?
25,000 pages means what? Supporting you will see a register being what is there in PC Act cases? Unnecessary multiplication of documents. They have seized registers, bills, and all those things.
No, my lord, with greatest respect, that's
Then
a separate thing. That's a separate document which your lordship sees.
15,000 pages actually.
25,000
Basically,
double
the
side.
bulk.
statement along with those will the bills and all.
The statement. How many witnesses are you relying on?
164. In 1 day's time, 164 witness will we be able to read, my lord?
116. Effective witness, how much? Maybe 50 only.
It shows 164. The chart sheet shows. Please see the number. If something will be said over here, the records speak of something else. We are before your lordship, my lord. If your lordship wishes that this travesty will happen, my lord, we will accept it.
Basically, how many Caesar list witnesses are there?
Huh? 164 বলছিলে কেন? তুমি তো বলেছো। 116, I'm sorry.
25 Caesar list.
At least 116 witnesses.
Formal witness also.
How will we know who's the formal witness?
খুব বেশি হলে 50টা সাক্ষী থাকবে।
At least we give us time to read state. Yes, in this vast knowledge, we've given them vast documents. Why have they given us vast documents? But they have relied upon, it's not our case. It's not defense documents that we are producing before your lordship. They have given us 25,000 pages plus list of 99 pages.
No, Mr. Manager, I'm not going to interfere.
My lord, what, my lord, may I just indicate to your lordship? What do
you can take time, sir. I'm ready for sitting. But then you got to go to the appeal court to get my order reviewed. Otherwise, it's not possible.
My lord, your lordship would pass an order to that effect.
My lord, may I just, CRAN 2, once your lordship frames your lordship's mind in 3, mine will be in fracture. My lord, may I just add to what Mr. Banerjee has said? But so far the nomenclature is concerned, my lord, the little idea which I have or rather experience. Madam,
Yes.
if your lordship is always on the merits of the matter. My lord, if your lordship sees my CRAN 2, kindly sees the cost title, my lord, this was for an appropriate order. And so far the prayer is concerned, my lord, at page 12, your lordship can see the prayer. I have prayed for addition of party as well because I was not a party.
None of us have any copy of Mr. Bhattacharya's client.
Everything was served, my lord. This is the by election.
We have not received anything. We have received a copy of the application of Mr. Banerjee's client. No copy of the application of Mr. Bhattacharya's client.
But he's
Mr. Bhattacharya's client earlier application was rejected for addition.
It is comfortable with you, na? It is comfortable with you.
Served upon the petitioner also.
Well, it's there in the mail, my lord, electronic mail.
No, electronic
But
mail
these are my prayers.
have not been
Now,
also
Tarsley, my lord, Tarsley is saying what the learned trial judge has said after, madam, may I just, that what learned trial judge has said, my lord, his inability with deepest respect to follow law. Now, my lord, we are before your lordship, my lord, before the constitutional court. Issue is, my lord, whether there will be a trial in accordance with law or not. My lord, what Mr. Banerjee,
Trial will be in accordance with law, sir.
for 60 days time.
So far as charge, these are all directory A provisions, sir.
My lord, for me,
You are-
my lord,
you are
kindly appreciate,
converting
my
that
lord.
into a mandatory.
My lord, I'm sorry, my lord. Subject to correction by your lordship. It's directory for me. The use word is, my lord, I may file. It's my discretion. If within 60 days I don't file, my lord, then I cannot be forced. I'm foreclosing my right. But it's up to 60 days, my lord. I cannot be forced that no, you curtail that. Number one. Number two, my lord, with deepest respect. Was that provision brought to your lordship's notice, my lord? The answer is with deepest respect, no. Second issue, was it brought to your lordship's notice that they are not ready with the copy? My lord, the unreliable documents are stored in 3 almirahs. There was an inspection, 55 documents sought for, that was refused. My lord, RUD refused, my lord. Verification refused, everything was refused. Now, my lord, what happened, my lord, on 1st of February, my lord, 25,000 pages document, neither paginated, my lord, nor indexed. Thrown at our face. And we are asked to prepare a, my lord, discharge application before the court. Now, my lord, the test before your lordship, my lord, the test of justice with deepest respect is the common man, my lord, the prudence of the common man. My lord, who on earth is supposed to read and prepare and effectively assist a court, my lord? My lord, at the bottom of everything, my lord, is the justice delivery system. We are rendering assistance. My lord, we are not. My lord, that's without prejudice. I'm sorry, Mr. My learned friend has not seen that. That's without prejudice.
Taking down blood is no manner of
My lord, this is the discharge application.
in 60 days he has already filed the application. The law.
We have said that's without prejudice. We are constrained.
Your lordship knows better than us. Blood 482 and 226. 482 blood abuse of process of a court of law. But if they are aggrieved by any order passed by the learned court below,
Well, we are not, I filed revision today, the court didn't interfere because your lordship's order is staring at us. And my lord, so far,
covers this.
Huh?
Budhya Swain's judgment covers this. 1999 4 SCC 396. If there is, I'll read it out. Thank you.
just give me
In our opinion, or tribunal or court may recall an order. My lord, with greatest respect.
No, please.
Just aiding Mr. Bhattacharya. An earlier order made by itself, if the proceeding culminated into an order, suffers from inherent lack of jurisdiction, and such lack of jurisdiction is patent. There is exists fraud or collusion in obtainment of judgment. Third, there's been a mistake of the court prejudicing a party. Third point covers us. Budhya Swain covers us, and we have the right to come before your lordship. Fourth, also, a judgment was rendered in ignorance of a fact that a necessary party has not been served at all or at diet, and the estate was not represented. This is slightly, but we were a necessary party. The Supreme Court is saying that this can be done. It can be recalled.
And perhaps this is Antule, my lord, where the earlier order was recalled by the Constitution bench. So that, my lord, no party is prejudiced.
Would your lordship allow this prejudice to happen when we are all in custody? Whom would it affect? It won't affect anyone.
No, sir, because you have got to come properly, because now it's not. You see, you are being aggrieved by the consequential orders passed by the.
We are, accept our statement.
Why are you then recalling? You should go in appeal.
The higher court was of the opinion. Your lordship would just with greatest respect. These are my submissions.
You say you are wanting.
My submission that I had moved unlisted in view of the extreme exigency. I had moved unlisted before the higher court. The division bench. The division bench says that since you are not even heard, it is incumbent duty for you to go back and indicate to the court that this is what has happened. I am giving you leave. And that is the reason why that leave is reflecting in the order. Your lordship, if your lordship is disbelieving, your lordship would indicate.
No, but then see, one thing is that
yes, my lord.
Over here, you have been granted leave on these application.
Yes, my lord.
The leave doesn't mean that it is automatically allowed. Leave has been granted to move. You move the appeal court, sir.
Leave has been granted to move your lordship's court.
Leave, that does not mean that has to be allowed.
Very well, my lord. Your lordship has heard my submissions, my lord. Your lordship would kindly record that. Your lordship would kindly, if your lordship is desirous, I have shown your lordship the judgment. Your lordship would kindly record that, and your lordship would pass an order. I would beseech only one request. One. I have only one prayer. Tomorrow, 10:40 is the time. Right. I would have to move the appellate court because your lordship is of the opinion that possibly your lordship is not inclined to entertain. Right. So your lordship would at least direct that I must have some breathing time tomorrow morning to move the writ court. That is all that I'm praying, my lord. About the division bench. If the lower court goes ahead, then this whole idea of all the law which is there would be rendered infructuous. Your lordship would direct the trial court to just adjourn.
That is almost entertaining your petition, sir. The prayers. The basic.
No, it's for temporary period, my lord. May I just, so far, my lord, appeal is concerned, there is one difficulty perhaps. Your lordship kindly remember, my lord, para 76 of Antule. If an order was passed in violation of, my lord, my natural justice, then your lordship will not take me amiss, my lord. Then the order is irregular. And if an order is irregular, my lord, then I have to file an application before that court. My lord, kindly see para 76 once from Antule, my lord. My lord, I'm so sorry, I have in tab, my lord, I have this. If I may.
Antule is quoted in Mr.
I don't know whether this may I just read it out?
Same paragraph is quoted.
My lord, the Privy Council in Isaac versus Robertson, my lord, that was quoted, my lord. He is a faster thinker, my lord, Mr. Banerjee, I know that. But whether this particular paragraph was quoted. Because my lord, para 76, which I have learned from your lordship only, the Privy Council in Isaac versus Robertson held that the orders made by a court of unlimited jurisdiction in the course of contentious litigation are either
130 has been quoted from Antule.
Oh, my lord, kindly comes to 76 once, my lord.
The three things, I mean, Antule is series of Antule.
Right, my lord. This is the, I think.
These are the three issues which have been quoted over here.
Mallam, may I just request your lordship to see 176, my lord? Oh, your lordship is having a photocopy of the judgment, my lord.
So that judgment which he has placed.
That judgment. But kindly see the original, the parent Antule, my lord. Well, kindly see 76. But we can't file an appeal, my lord. That's the difficulty. Subject to correction by your lordship. But the Privy Council, I'm so sorry. My lord has got it, my lord. I'm obliged, my lord. The Privy Council in Isaacs versus Robertson held that the orders made by a court of unlimited jurisdiction in the course of contentious litigations are either regular or irregular. If an order is regular, it can be only set aside by an appellate court. If it is an irregular, it can be set aside by the court that has made that made it on application being made by that court, either under the rules of that court, dealing explicitly with setting aside of the order of irregularity or ex debito justicia. So, my lord, then apropos this, my lord, is one more paragraph. 57 once, my lord. Kindly see, my lord, if natural justice violation, my lord, then it's irregular. 57, my lord, subject to correction by your lordship. My lord, it's. My lord, then again, 57, my lord, Seventh line from the bottom. But at the end of the day, my lord, we are prejudiced, my lord. We are before a constitutional court. The order was passed when we DPS system, my lord, the court was not properly apprised of the facts and circumstances. Learned trial court said, sorry, I'm not going to follow the law because the order is staring at me. And my lord, the legislature in its wisdom has provided us 3 days time, my lord. My lord, the bottom line is whether there will be a fair trial, my lord, with DPS respect. And we are at the receipt, we are in custody.
Just 1 minute.
It was not brought to your lordship's notice, my lord.
Madam, the phone will appear in Tapir on behalf of the petitioner, but right now he is at Prayagraj.
ठीक है,
for
ठीक है,
the-
So therefore, my lord, this review or recalling, my lord, subject to correction by your lordship is maintainable, my lord. Now issue is whether your lordship will recall or clarify that portion, my lord.
And all that
When we file 482 court, you will say, my lord, definitely, my lord, this is by this honorable court.
all that we wanted was a little more time in terms of the law.
Nothing else, my lord. Your lordship may pass necessary direction, the law to be followed, my lord.
That's
The directives of this new court, my lord, will be followed.
That's all.
We all respect that, my lord, because we are bound to.
Lord, may I say only one thing?
Just 1 minute, sir.
If the pages were at least paginated and an index was given. I mean,
Hon'ble was taken into consideration by the Supreme Court.
by the Supreme Court. In which matter,
I think the judgment Mr. Banerjee has relied on.
No. Then 2015-5 SCC, where it says that judicial orders cannot be interfered with.
we are
My lord, we are not judicial orders shown the consequences, my lord.
consequences to what
We are not on, my lord, there is no judicial order cannot be, my lord, under 226. My lord, in our
But there has been already a consequential changes. What you are wanting today, you have got to appreciate, is reviewing the earlier order. Now, reviewing means I have got to hear all the parties.
only my
that will not-
that party is concerned, my lord.
No, that cannot be ex parte. Mr. Tiwari is
But
not there.
say that operation of that portion, my lord, for the time being.
there is no imminent trouble. We are all in custody.
My lord, the bottom line subject to correction, my lord, whether the justice will get justice or not. My lord, everybody has a right to fair trial at least, my lord. Right, my lord. In a country like this, my lord, where everybody obtain, my lord, a fair trial, my lord.
We are saying we want to follow the rule of law. The courts have to follow the rule of law.
Sure.
My lord, we are not with the judicial orders. We have shown the consequences before your lordship.
Acha. Petition. Acha. Leave was granted aid by